If you've inherited a house here in the state of Ohio, especially if you live out of state, you're probably Googling the same thing everyone else does. How does probate work in the state of Ohio? And how do I sell this inherited house fast, right? And listen, you're right. You're thinking this is going to be an absolute nightmare. There's probate court, there are the taxes, and there's the house just sitting empty. And maybe brothers and sisters that just can't seem to get along and agree on anything, let alone the fact that you're grieving the loss of a loved one. And listen, I get it. There are some truths to what you're going through right now and what you're finding online. And it can be complicated, absolutely. But here's what those articles that you're finding on Google right now are probably actually missing, and you don't have to figure out every single legal detail before you can actually move forward. There's a specific order to do this in the state of Ohio. And if you follow it step by step, you can protect your equity, sell it as fast as possible, and honestly, keep the family peace and keep the family together. So let's dive into it. So my name's David Moyer. I'm with Keller Williams Advisors Real Estate in Dayton, Ohio. Also with David Moyer Real Estate. I've been a full-time licensed real estate agent here in Dayton, Ohio for well over 21 years. I want to be your friend in real estate and your friend in Dayton, Ohio. I hope you find this information I'm about to tell you here useful. Check out my channel for other things real estate related and Dayton related. Make sure you like and subscribe. I grew up in the area, I live here, and I've sold homes pretty much in every single suburb in the greater Dayton area, from Beavercreek to Oakwood, Centerville, Kettering, Springboro, and I know the ins and outs of all these neighborhoods like the back of my hand. And a big part of what I do is helping families navigate probate real estate, especially when someone out of state inherits a house here in the Miami Valley and has no idea what to do next. In this video, if it helps you, like I said, make sure you like and subscribe, share it with some family member that maybe is going through this process right now who needs to hear that it's not that complicated and they're not alone. I do answer all of these comments myself. I answer them personally. So drop a question below if you have a question, or if there's something you feel that I missed and you want some further explanation, or if you want to set up a private consultation. And if, like I said, if you want to talk one-on-one, there's a link below, or you can always call me directly, 937-477-2298. So let's dive into it and let's get into the details. So let's actually start with step one. Great place to start, right? And this is the most important one. Who actually has the legal authority to sell the house? If the house was only in your loved one's name, it becomes part of the probate asset. That means you cannot list the house tomorrow. Someone has to be appointed by the court itself. Now, if there was a will and that person is called the executor and they were named in the will, and if they would be the person that is in charge of executing this moving forward. But if there is no will, the court appoints someone that is called the administrator. Either way, that person takes that estate and goes to probate court to get a document called the letter of authority, sometimes called letters testamentary. That's right. So think of that as your permission slip per se. Without it, a title company can't close on the sale. So you have to have that permission slip from the probate court before you can close on the property. So here's a quick tip. If the executor was given the power of sale in the will, it is much easier. So you don't have to go back to the judge for permission on every single decision. The probate attorney will tell you if you have this or not based off of how the will was laid out, how it was executed, and how it was recorded. So every single case is different, but depending on what your outline is, this is your first step. Which brings us to step two. You have to file for probate in the right Ohio county. You can't just go to any probate court. And that's always the county where your loved one lived, where they were a resident, not where you necessarily live if you're also in the state of Ohio. You file the will and the death certificate in that county. Now, I have to say, I am not an attorney, so this is not legal advice. I'm a real estate agent, I'm a realtor. But in Ohio, this process typically takes anywhere from 6 to 12 months. It can take a little bit less time depending on how your loved one had their will structured and how much debt and assets they have laid out, of course, and which county you're in and how fast that probate court is moving forward. So the sooner you get that filed, the sooner you can actually get to closing on that property. And listen, if it's a very, very small estate, There are shortcuts. For instance, if it's under, let's say, $35,000 total or under even $100,000 total, and it's all going to a surviving spouse, you might qualify for what's called a release from administration. For even smaller estates, there's a summary release. All right? An attorney can tell you actually in a matter of 5 minutes if you qualify for either one of those, so you can skip a lot of the waiting period for most estates. By the way, quick check-in here. If you're just joining us, my name is David Moyer. If we haven't met, I'm with Keller Williams Advisors Real Estate in Dayton, Ohio. Lived here my entire life, been doing this for over 21 years. If you're feeling overwhelmed already, that's completely normal. This is a lot to take in. This is a lot to carry, especially if you're coming from out of state. So if you have a quick question, drop me a comment below, give me a call, shoot me a text. I answer all of those personally, and make sure you hit subscribe, right? So let's keep going. So let's talk about step 3, which is actually the financial reality. You need an appraisal. You need an appraisal and you need to understand your taxes. This is where things get really minute. And this is actually good news for most heirs of estates. The IRS itself gives you what's called a stepped-up basis. Let me say this in plain English, all right? Let's say your parents bought their house for $80,000 30 years ago. I know what you're thinking, $80,000, where do you find a house? Bear with me. They bought the house for $80,000 30 years ago, but it was worth $250,000 the day that your parents passed. For tax purposes, the IRS resets the value to that $250,000. So if you sell it pretty quickly for around $250,000, you may owe little to no capital gains whatsoever. You only pay on the profit above that stepped up value. And here's another Ohio benefit. Ohio itself eliminated its state estate tax years ago. And there's no state inheritance tax either. You can Google that. You still have a federal estate tax. That's unavoidable currently, but that only kicks in for very, very large estates. So if you're a moderate to low estate right now, you don't even have to worry about that. That appraisal right at the very beginning, it protects you and your assets moving forward. It proves what the stepped up value is. So if you're looking to sell the property right away, that is going to protect your assets and protect any sort of taxes that you may be liable for and help you alleviate that tax burden. And now if you're looking to hang on to the property, that's also going to establish the value right away from the moment that that loved one passed away, so that you're only owing on those capital gains moving forward from that point on. Now, step 4 is the part that a lot of families don't think about, and this is where I kind of step in right away. Step 4 is where out-of-state families get hurt if they wait. You have to secure the property. The property is still there and it's vacant, and really, truly, it's public knowledge. There's probably an obituary that was in the paper, and public records show that that person is no longer living in that house. And you need to stop the bills from bleeding you as well. Those bills are going to continue to go whether that loved one is still in that home or not. First of all, change the locks. You don't know how many keys exist out there, who has those keys, and who is going to re-enter the property either with good or ill intent. Tell the local police that the house is vacant so that they can keep an eye out, do regular drive-bys, especially on the weekends or the evenings. And please hear me out on this one. Call the insurance company. A standard homeowner's policy that they have on the property right now does not cover a property that has been vacant for 30 or 60 or 90 days. You think you can keep the same homeowner's insurance, but if something were to happen later on down the road and it was 60 days and that home has been vacant, that policy may be null and void. You need a vacant home policy actually once your loved one has passed and no one else is living in that property. Otherwise, if a pipe bursts or if there's any sort of smoke damage whatsoever, you're probably not covered, and now you're stuck with paying all of that out of pocket. And those bills, like I said before, they don't actually stop because no one's living there. Property taxes, they keep going. Trust me on that. Utilities, lawn care, if they had lawn care service, you definitely want to keep that up, and those aren't going to stop. Insurance, we've talked about that. They keep coming every single month. They're not going to stop, and you're just sitting on it. So that's why moving efficiently matters when it comes to estates, and you want to make sure you have all your ducks in a row. I can help walk you through that. I've got a great checklist. Now let's talk about where families get stuck. And again, for those of you that's just joining me, my name's David Moyer, your friend in real estate here in Dayton, Ohio. The next part is all about disagreements and your options to sell. If you're watching this from out of state, drop in the comments where you're watching from and which county your house that you're dealing with is in. I do read and answer all of those personally. And if it's not in a county that I handle, or if it's a part of Ohio that I personally do not handle, I can put you in contact with an amazing agent that can help you walk through the probate process and the estate sale process there in that area, in that part of Ohio, or frankly, anywhere in the country. And if you want an honest, no pressure opinion, text me photos, text me the address. You got my number here below. There's a contact information below. I'll tell you what to do and if it was my family. So let's move on and talk about getting family agreements. All right, step 5 is getting everyone on the same page. And listen, not everything is peaches and cream. There has to be emotions involved, and this is the stage where things start to get really emotional. If the executor has the power of sale in the will, so they had it from the get-go, they can make the decision alone to sell the property. If they don't, you generally need written consent from all the different heirs, or the court itself has to approve the sale of the home. Now, in a lot of circumstances, even if the executor is named in the will, I do see a lot of family members that will still get written consent from all their siblings, but they don't have to technically by law if they are named the executor in that will. So, if brothers and sisters left behind simply just cannot agree, the last resort in Ohio is something called a partition action. It's basically a lawsuit to force the sale of the house. It works, but it's expensive, it takes months, and it absolutely strains family relationships in a time where those relationships are typically already strained. We want to avoid that at all costs if possible. So communication early on is everything. And I can walk you through that. I like to come in as a neutral party and help you walk through this and explain all of your options up front. Communication is key. Step 6 is choosing a strategy. And you have 2 main paths, right? Path A is the traditional sale. We clean it out, we do some repairs if necessary, we stage it or we virtually stage it. We list it on the market to get top dollar, and that usually gets you the most money. But it takes some time and it can take some cash up front. So depending on what your circumstances are, that is option A. Path B is selling it as is, right? So you sell it exactly as it sits. You don't do anything. There are no repairs. There's no cleaning out of every single closet. It's fast, it's convenient. A lot of times you'll sell these to maybe a cash buyer or an investor, and you might actually net a little bit less, but you can save a little bit of time, some months of holding costs and headaches in terms of doing all the work up front. There's no wrong answer here, guys. At the end of the day, it just depends on what your timeline is, what your cash on hand is, and really truly how far away that you live. I have clients that will call me from out of state and say, this is what we want to do. We like option A, but we live 3 states over. We're only going to be in town for a short period of time. Can you help us make these arrangements? And I absolutely can do that for you. I have contractors, I have cleaners, I have all the personnel on hand that I can set you up with and get them into the property to do this for you while your state's away. But that's going to take time and that's going to take some money. So it's completely up to you and what your goals are. Like I said, there is no wrong answer. One thing to know, even if you sell as is in Ohio, you still have to fill out a property disclosure form. But estate fiduciaries, just like executors, do have some exemptions. So your agents, such as myself, and attorneys will walk you through exactly what you do, and you do not necessarily have to disclose. There are residential property disclosure forms, and some people, when they're selling their estates, will fill them out just as if they had lived in the home. There is an Ohio residential property disclosure exemption form that is made exactly for executors that simply states we have nothing to disclose because we have never lived in the property. Therefore, we don't know anything and we don't feel comfortable even answering any of these forms. Therefore, we are exempt from answering a residential property disclosure form. Now that we got your house under contract and we got your estate sale moving right along, and we're headed to the closing table, step 7 is closing and actually getting paid in terms of closing everything out. A title company and a probate attorney will handle all of this for you. They clear the title, They pay off all the existing mortgage, the liens, the estate debts, and the money, it doesn't go straight to your pocket necessarily. It goes into an estate account first in most circumstances. Then it pays the court costs, it pays any sort of attorney fees, it pays executor fees if there are any, and only after the court approves the final accounting and closes out the probate does the remaining money get distributed to all of the heirs. And that's the process as is, at the end of the day, to distribute all the money. Now listen, before I go, I know this isn't just a house. It's your mom and dad's house. It could be your aunt or uncle's house. It's closing a chapter. It's not just closing on a building. And you don't have to do it alone. The time to get started is always yesterday when it comes to estate planning and estate sales. But the second best time is today, right? So once again, my name is David Moyer. I'm with Keller Williams Advisors Real Estate and David Moyer Real Estate right here in Dayton, Ohio. I've lived here my entire life. I grew up in Springboro, class of 97, and I want to be your friend in real estate, and I want to be your friend in Dayton, Ohio. If this helped you, please like, subscribe, share it with someone else who you think could benefit from this, or maybe is going through the estate planning process, or is looking to sell a loved one's estate as well and just doesn't know where to start. Call or text me anytime. The number's there, 937-477-2298. I'm here to help, and we'll talk soon.